Good afternoon. Good afternoon. Hello and welcome to Live with Just Us, Jail USA's Facebook Live discussion series. My name is Hakeem Crampton, and I'm joined by my colleague Lester Young. We are the Movement and Capacity Building Specialists for Just Leadership USA. And it is our distinct honor to amplify the voices and give power to those who have been directly impacted by investing in people, by educating and empowering and elevating the voices so that they have the tools and the resources to self-organize and advocate for themselves, their families, and their communities. Together, we build an equitable, fair, and just United States. In 2016, 2.2 million people were incarcerated in the United States in jails and prisons, but more than twice as many, 4.5 million people were under supervision. Parole and probation have been shown to increase incarceration, and Black and brown people are both disproportionately subjected to supervision and incarcerated for violations. It is a system to control those labeled as dangerous in the name of public safety. Instead of providing any solutions to the real drivers of incarcerations, we are assessed and evaluated for our dangerousness from our first appearance in society as a Black man. So today, we're joined by a distinguished group of panelists, professionals, and experts in this field. We will have a great discussion about probation and parole, what's happening with the state of probation and parole across America and in certain states in particular, and where do we go from here? How do we address this aspect of the carceral system? And so I have a distinct honor of introducing you to Dr. Alexandra, juvenile defender, advocate at South Carolina Commission on Indigent Defense. We also are joined by Nicole Porter, Director of Advocacy at the Sentencing Project. We also have Shireen, the Criminal Justice Policy Council at ACLU of South Carolina. Thank you all for joining us. We're going to get started with some questions. And the very first thing I would like to say is, as a person directly impacted by the criminal justice system, sadly, I've been on parole now for 15 full years after having served 15 years in prison. And so I've dealt with parole, and I had such a personal experience with parole. And so I thank you all for actually coming on and sharing your expertise, because for someone like me, as personal as this is, there are so many other people that this is just as personal to them and their families. So I would like to get started. And my colleague and myself, Lester Young, will go back and forth asking you guys questions and engage in a great conversation to learn more about the state of probation and parole in America and what we can do to bring about a change. So I'll start with you, Dr. Alexandra. For example, how do parole and probation feed into the criminal justice system and mass incarceration? From your experience and your background, you can tell us a little bit about your background and then explain to us how that feeds into the system.
Thank you. Thank you so much, Hakeem, and thank you, everybody, for this opportunity. I really appreciate that moment for us to share our thoughts, and it's a learning moment for me as well. My background is in human rights, and specifically with focus on the rights of children, and my professional experience is in the realm of juvenile representation. I'm right now a research attorney for all the juvenile defenders in South Carolina, but I also have opportunity to represent and be involved in cases for adult parole. Unfortunately, I have been passionate about juvenile work with the idea of reducing recidivism and reducing the whole cycle of incarceration. And it's always been my conviction that the more energy we can invest in youth, it will then translate into fewer numbers of people being incarcerated for longer periods of time or clearly at all. I've been disheartened throughout my work in South Carolina that process is not as it doesn't work the way we would like it to work. That we can put all energy into things and then the results are just not as tangible. And I do see that because I also am involved on the at the other spectrum. When I am involved with adult cases, I see how hardened the system is and how little the system pays attention to the humanity of people that they deal with. Specifically, when it comes to the parole board, as you asked, Hakeem, our parole board in South Carolina is not as interested in the human that they see that's being in front of them for release. And that's extremely discouraging. I mean, we can talk about dehumanization of Black people or people of color in America, which starts from the very beginning when children roam around streets and communities through the school process, school involvement, and then the pipeline that exists from schools to the juvenile justice system, and from juvenile justice system farther on to criminal justice system. And the role of the parole board should be to definitely contribute to safer communities. Yet I don't think the way the parole board operates right now in South Carolina specifically, that is the goal as they understand it. Perhaps this is the goal as they use for a justification of their decisions. But I really do not think, based on research and studies of public health and communities and what really works when it comes to reducing recidivism, continue to keep people incarcerated and allowing them to die in prisons does not translate into safer communities. So we can look at the humane aspect and how them not paying attention what's humane about the human in front of them is wrong. But also the fact that communities are not safer by having thousands and hundreds of thousands of people incarcerated, that actually creates unstable communities, because many of these people are fathers and brothers and uncles and members that should be back in the community, contributing to the well-being of their families and safety of our communities. So our parole board has a very low release rate for our people that are incarcerated, and unfortunately that contributes to the cycle of mass incarceration as I see it.
Wow, that's powerful. Thank you so much for that. I have a follow-up question in relation to that. So once people are incarcerated and they're sentenced to serve a portion of a time, what's the pathway to release for them? What are some of the assessments and evaluations, for example, that the state of South Carolina uses that allows people to access pathway to release?
So interestingly, and perhaps Shireen can help me with that a little bit, because as our law says, there is a risk assessment process, and I have requested to have more information about that assessment process from the General Counsel on parole, and I have not received it. They said that's the confidential information for the parole board, and if other agencies have it, I would love to see it. In the process of my representation of adult clients, I have not ever seen that risk score that parole board creates to assess, and in a case when they do not release a client, they share a very general rationalization for their decision. So they really give very little information for us to go forward with another attempt of representation of a client, and that's a huge problem, and that's something that I definitely believe we need to focus on. That lack of transparency, it creates this vicious cycle of us just attempting things without any rational basis for it. There are 16 factors. There are 15 actual factors plus anything else. So there are 15 factors for the parole board to consider, and those factors are public, and definitely everybody that goes in front of a parole board can access those factors and can look. Of course, it's about the position of the victim, the position of the community, whether a person has a possibility of being employed, and what is the family support, community support. So there are quite a few very explicit factors, and that is helpful. Yet our parole board has absolute discretion not to take anything into consideration and make a decision based on what they believe make the decision on. And that decision can be, again, very generally explained to people that are rejected for release. And that is absolutely not helpful, because it just feels like, we're shooting darts in the dark room and we don't know what's happening there. So there is some guidance, and I definitely would encourage everybody who is going through this process in South Carolina to acquaint themselves with that, and that information is very readily available. Yet sometimes we feel like we exhaust all of those attempts to show all of these achievements that people that are incarcerated have done, and they have great community support, and they have jobs, possible jobs, and they have all kinds of letters, yet the parole board chooses not to release them, and we sometimes it's we just don't know where else to go and how else to find out, because we really do not see what that risk assessment is for them. And just a very brief example that I will give you, for a person that I have recently been involved in for parole representation, I will call him James. We received even a letter from our mayor of the city where he would be going back to, saying, yes, he is welcome. James is welcome in the community. In the mayor's opinion, he poses no risk. Of course, everything else was there: community support, family support, medical records. So, but we thought obtaining the letter from the mayor would really make a difference, and it did not. So that's what I'm talking about, this disheartening process of we don't know what else to do.
As a person who lives in South Carolina, who served a total of 22 years and 5 months in South Carolina prison system, and was eventually paroled my second time on a life sentence in South Carolina, and now been home a total of 7 years and was pardoned by this system as well. So when I look at this system today, I believe that there's still a whole lot more change that has to happen, because I've been granted my parole. I was granted parole after serving that amount of time and eventually was pardoned. But I still see that the system has a lot of broken pieces that needs to be fixed, right? Because some people say, well, Lester, why are you saying that the parole board or probation and parole or pardons in South Carolina or across this nation needs to change when you've been granted that same accessibility? You was granted parole. You should be the least person to speak about it. But I believe that my granting or relief or freedom came with a price, and that price was to be an advocate for those who are currently still in a system that is being denied accessibility. I talk to friends on a consistent that are still in prison who have served 35 years, 40 years, 20 years, and have been in prison when I met them at 19 years old, and they're still in prison and have done everything imaginable to do to prepare themselves for this, but unfortunately they're not able to go to that. So Nicole, before we get into this anymore, do you have anything you would like to just add to this conversation around how do parole and probation feeds into this criminal justice system before we move on? You and Shireen, after Nicole, then Shireen, you can feed in as well.
Sure. Well, thank you all so much for including me in the conversation. My name's Nicole. I work at the Sentencing Project as the Director of Advocacy, and Sentencing Project is a research and advocacy organization that's been around since the mid-'80s. And we do many things related to sentencing reform and collateral consequences. So I want to touch on a few of them in the context of your question there, Lester, and thank you so much for sharing about your experience. A few years ago, we launched a campaign to end life imprisonment, and I think around the issue around people currently living in the community on parole or probation, of which, in some states you can be on lifetime parole. Particularly in your experience, Lester, I don't know if this is true in South Carolina, but I know in states like Tennessee and Kentucky, if you are actually paroled, but the underlying sentence was a life prison term, then your parole term is also life.
Exactly.
Supervision. Yeah. And one of the major contributors to prison admissions each year are technical violations on parole and also probation, so on community supervision overall. So I think there are a lot of things to touch on, given the extreme sentencing that drives prison length, including those life imprisonment terms, and the extreme policies that might drive lifetime parole sanctions for people who are on parole eligible life sentences and then ultimately get released at some point during their imprisonment. So one thing around addressing the technical violations that might be driving prison admissions is to have a presumption against incarceration or imprisonment for the technical violations. I'm sure it's no surprise to most of the people who are listening in what technical violations are, but I will describe them briefly. These are not new crimes. These are codes of conduct or practices that people in the community are subjected to if they're under community supervision. You can be violated for showing up late to a meeting with your supervision officer. You can be violated for not answering a phone call from a supervision officer. There's a notorious incident over the last couple of weeks that dominated the news. People might be aware. This elderly woman in DC was violated on a federal, who was on federal parole back to the federal prison, and she was detained in the local DC jail until she was released a few weeks ago. But they were trying to violate her because she was in a computer class and she did not answer the phone call from her parole officer. And there's many instances like that around the country. So in addition to that, as part of our campaign to end life imprisonment, a major solution that we are trying to organize and build momentum for is to have maximum prison sentences overall of 20 years or less for even underlying convictions that may be very serious ones, including crimes of violence. Repealing life without parole, thereby adjusting downward what the maximum sentence might be for even violent and serious offenses, hoping that can help adjust and recalibrate state criminal codes and creating space for release. And then there are other policies too that are a part of our vision, our approach to reorienting, reimagining parole, if not undoing it outright, given the extreme conditions that people are subjected to, including expanding who is currently eligible for release through those criminal code reforms that would lead to a 20-year maximum sentence overall, undoing life without parole, life parole outcomes. And I think in addition to the factors that Alex mentioned, what parole boards consider towards release, including those factors in criminal statutes, creating a presumption towards release is also a strategy that we're working to popularize and support in state coalitions that are looking at moving that forward. So there's a current practice that's having some success called Second Look. That's where a court option can be established either by a prosecutor or the defendant themselves, the directly impacted person themselves, initiating a court proceeding for a judge to review whether or not that person needs to continue to be in prison. In the District of Columbia, people convicted under district code offenses who were 25 and younger at the time of their offense can petition the court for a second look hearing. This is a proposal that's recommended by the American Legal Institute, and other legal practitioner organizations are really advancing efforts to create these non-parole court proceedings. And there's federal legislation that Sentencing Project in coalition with other groups is really supporting and organizing around. It's called the Booker Bill. It was introduced a few years ago. It would create a presumption, a court proceeding, and a presumption towards consideration of release that includes several factors, many of the factors Alex just considered, but it wouldn't be sort of a policy that discretionary parole boards could consider. It would be in the code, hopefully advantaging a court process towards the impacted person to not just have their crime of conviction considered, which can never be changed, balancing out the disadvantages that people experience in risk assessments and other assessment practices, but also considering any institutional programs that the person might have participated in, any efforts towards personal and self-development, and considering who the person may be at the time of the court proceeding, not who the person may have been 15 to 20 years before. So I'll stop there. And, I went through that pretty quickly. So if there are any questions, I'm open to them. But those are a couple of the ways that we're looking at reimagining, if not undoing the extremeness that drives parole and community supervision policy in the United States.
Nicole, you definitely said a whole lot. And it's very important information. Hopefully get some time to unpack this because it's something that I know so many people, family members, as well as those who are currently incarcerated, they're looking for bills to be passed, that second look, where individuals feel completely exhausted in prison, felt like, as I said, have done everything that they possibly can, have met all of the criteria, but for some reason they still are unable to get that release. So we'll definitely come back to that to unpack that as far as just that second look and some other things that you're speaking about. Shireen, I noticed that the ACLU shared some information recently around probation and parole. The critique of the ACLU about probation and parole here in South Carolina. Would you like to just share a little bit about that, and then we'll continue to dig a little deeper into this conversation?
Sure. Thank you so much, Lester. It's good to see you, and nice to be here. Thank you both for inviting and including me. My name is Shireen Hensodia. I'm with the ACLU of South Carolina. I really appreciate being included in this conversation. I've worked as a public defender, and then now with the ACLU of South Carolina. We just released a report, actually, that covers on a lot of these topics called Reevaluating Crime and Punishment in South Carolina. And there's a large section on the parole system, the probation system, and covers a lot of these issues. And I won't reiterate a lot of the excellent things that both Alex and Nicole have already discussed at length. I'll hit on some high points, rather low points, I should say, about our parole system. One is that it has greatly reduced the percentage of people that it has released over time. So 1980, they had a 63% release rate. And by 2008, it was down to 10%. Now we're up a little bit again because they received a lot of criticism, the board did. But we have one of the boards in the country that is not a professional parole board. They do not have a background. They do not require a background in a criminal justice field. We have a doctor who's an optometrist and several other people on the board that have absolutely no connection or relationship to criminal justice issues at all. That's one critique. Another critique is piggybacking on what the other ladies have so eloquently said. The board seems to perceive their job as predominantly denying people parole. And they have a very disparate treatment of people based on whether or not they have the resources to bring a lawyer. And also depending on who that individual lawyer may be. If it happens to be a legislator and an individual that's also a lawyer, they'll probably get a lot better result than someone who unfortunately cannot afford a lawyer and is speaking on their own behalf. That person will likely get 1 or 2 minutes tops. And it feels like a very rigged system because it truly is a very rigged system. Having represented people in front of the parole board and written several pardon letters, I will say that the pardon process is much more hopeful in South Carolina than the parole process. And I would agree with Nicole on a number of the things that she said about second look sentencing. Also, the presumptive parole systems that have been implemented in other states, some in the South, like Mississippi and Louisiana, where the presumption should be turned on its head. The presumption should be that at the earliest point of parole, you should be presumed to be released, absent objective reasons to say that you need to be held in prison longer, such as things like trying to contact a victim or continuing to have disciplinary issues inside prison, but not subjective reasons, which is almost all of the factors being considered in South Carolina would be considered subjective. And that is, all the research shows not the right way to go. A few more points I will touch on very briefly because I know we want to move along.
Yeah.
We should have a lot of different reforms to our system. We should have people get more earned time and good time credits to get out earlier. And when they're on probation, same thing, to be able to get off of it. Probation and parole should be goal-oriented. When you complete the goals that are required of you, you're off, not based on time. And sentences as Nicole brought up, should never be as lengthy as they are in America. We are the only country on earth that not only incarcerates far more people than any other place, but for far longer periods of time. And all the research shows that people not only age out of crime, but that long sentences are only punitive and they're not effective. They're not effective in a monetary sense, and they're not effective in a rehabilitative sense. They are only punitive, and they're retribution. And I'll stop there. But just sorry, I could keep going. I know we can all keep going on these issues.
It's really good. Like I said, being a formerly incarcerated person, you know, and still have connections with the population of men and women inside of the prisons here in South Carolina and across this country. You know, I know what it feels like, and I'm sure my colleague can agree, Hakeem, that it's a system where people feel completely just hopeless. And, you know, unfortunately, I've seen over the last 10 years in South Carolina prison system where individuals who will still feel like they're being not only punished for their crime, but they're still being punished for living in poverty. And what I mean by that is that they don't have the $20,000, $30,000 to hire an attorney to represent them for 5 minutes, right? So now they're like, I've done everything I can, but the board is not looking at me as a person of redemption. And I don't have the money to pay these expensive attorneys. So now I'm going to just sit in prison and hope that someday this panel, the people on this panel across this country is going to be truly advocating that we'll get some bills passed, that the people who are there, the black and brown people who are there, some of them in there as a result of poverty is still being punished for poverty because they don't have the money to pay for that. I'll pass my virtual mic back to my brother Hakeem, and we can go continue to dig deeper into these conversations. But I really appreciate it. And I'm pretty sure that the families of those who are incarcerated, as well as the men and women who will have an opportunity to one day hear the message you guys are saying, you all are sharing, would truly be inspired by this. And I just want to thank you all again for the work that you're doing around probation and parole.
Wonderful. This has been a great conversation, and thank you, Lester, and thank you for your input so far. And we have about a half an hour to kind of flush this out a little bit. So why don't we dig into some very specifics, right? So we know that at the court level that attorneys and lawyers are not fully aware and able to really represent people incarcerated for parole hearings, for example, right? There's never been advocacy for parole hearings, right? A person is up for parole, he or she appears for parole on their own with no help and support, and they're facing a system. So I want to look at this from 2 points of view. How do we build support for people at the court level, right? And build a network of attorneys who are experienced in parole and probation to provide this kind of support, right? So we can get to the second part of the conversation is how do we then infuse steps like that, aspects like that into the reform conversation about how do we build awareness about this and then actually move into spaces to make change. Mm-hmm. So I'll start with Alexandra again, Doctor.
Mm-hmm. Thank you. And this is really an important point, Hakeem, for many reasons. Of course, people need to be represented and have that access. That's by far. But what it does for a lawyer to represent the person on the other end versus in trial for court for sentencing is it informs the lawyer about the how extreme this system is. And then when the lawyer steps in and does the sentencing hearing, the lawyer can also inform the court about what it is like, how people are really not released. So it really, really works both ways. First and foremost for the people that need to be represented, which needs to happen and be expanded. But also it's this education process for our court system and our judges who really don't always understand what happens because we as lawyers don't always understand if we're not involved. So this is a really the right way to go about it is to have more lawyers involved. And I believe Sharon will talk about this because ACLU is right now a part of the larger initiative in South Carolina to create that network of people, of attorneys that will represent pro bono, all the inmates or all the people that are incarcerated that cannot afford. So I really believe in South Carolina we have quite a strong network of people that want to be involved, and perhaps because I'm now more involved, I see that it's happening. but there are more and more conscientious lawyers or community lawyers or lawyers who are not there just for the money, but they recognize also the value of their involvement in reducing mass incarceration and reducing the racial disparities and all this what we're part of right now. So I'm hopeful in that manner that with leaders like ACLU that are right now much more strongly present in South Carolina, we will get to the next step of representation for our incarcerated people. And that will also create the reform that you're talking about, Hakeem. I've just had an opportunity to look at some numbers because a client I was involved with has been incarcerated for over 40 years. We looked at how many people are in similar predicament in South Carolina, and we found that over 50 people are there for 40 years plus. Mm. If we put those numbers together and then also add another factor that we need to understand, that the incarcerated Black person in South Carolina, their longevity, their life expectancy is shortened by almost 22 years.
Mm. Wow.
That's a fact. That's something that epidemiologists have put together. And they said regular Black person in US population, their life expectancy is 22 years more than an incarcerated in South Carolina prison. So it's almost a miracle in my eyes that those people that are there for 40 plus years, they're still alive. And wow. They're there in my mind for a reason, because we need to really step up and do something about that. But then if you put it in the context, those are not only life sentences, those are death sentences. Mm. The urgency could be more. Mm-hmm.
Alexandra, we want to go to Shireen and then Nicole, and we want to just because of the time, this information is so much to unpack. We're going to have to narrow it down to about 2-minute response so that we can really get some call of action, but also give some education around this very important subject matter. So Shireen, you said you wanted to respond to that, and then we'll go to Nicole, and then we'll continue.
Sure. Thank you, Lester. And Alex, thank you for bringing up the program that we are working on. So after the release of the report I mentioned, the next initiative that we are rolling out very soon is a program where we intend to eventually, hopefully in the shorter, not longer term, have a training program for all interested lawyers in the state, free training, to represent people in a parole hearing. And we would ask that by providing the pro bono training, that individuals who take that training be willing to at least provide free representation for one, but we would really ask them to provide more than that, but at least one person in exchange for getting free training. We're also going to work with the law schools in the state and see if we can get some students involved in learning about the prison system. Mm-hmm. And so those two programs are hopefully going to start answering that need, because it really is a problem to have people who can't afford to have a lawyer get such unequal, unfair treatment in front of the parole board. And I'll just mention one other short side note. We have a pretty limited geriatric and medical parole release statute in our state. And the sad statistics show that even when we had a worldwide pandemic, when our director and the parole board should have been releasing far more people, they actually released less people in 2020 than they did the year prior. Mm-hmm. It's backwards. We need to change that. We need to change the mechanisms and vastly broaden who is able to be released through those programs, as well as through parole in general, and also work on those who aren't parole eligible, who actually comprise 64% of our prison population in South Carolina. And I'll stop and let others speak.
Cool. Nicole, definitely share your perspective from the national as well as where you're located at regarding this.
Yeah. Thank you for the question. So I think there's a few things. The legal capacity has not met up with extreme sentences, and there are a lot of legal protections for people sentenced to death, But for these extreme sentences, death by incarceration, too long prison terms, the legal capacity and legal remedies available to people does not match that on the capital defense side. So there's a need for that. Speaking to the work that Shireen is doing with the ACLU of South Carolina, I'm so happy to hear that. Other capacity like that needs to be developed in other states around the country. There are nonprofit law offices or civil rights law offices that do include representation for parole hearings and or sentencing relief for people who've been sentenced to these two extreme sentences. Some great work out of Ohio with the Ohio Justice Policy Center on their Beyond Guilt initiative, which is not about innocence claims. They take on too long imprisoned people and have worked successfully to get them out of prison by addressing the too long prison term that many of their clients have been subjected to. I also say that this is something that needs to develop. So the ACLU of South Carolina is doing this. There are these nonprofit legal offices like I just shared in Ohio. There's other examples of that in Louisiana, New York, in California. Clearly every state needs that. And even within states, a lot of capacity probably needs to be developed in order to support people's cases. I'll also say that there is a citizen-led strategy under this concept called participatory defense that at this point is focused on pretrial defense, expanding capacity for public defenders representing clients in the pretrial and sentencing phase. But there's no reason that capacity should only be limited to the sentencing phase of a person's incarceration or imprisonment experience. Participatory defense discussions could also happen to support people's parole releases. And then also if people are in the community and are at risk of being violated, could help support any potential outcome from a violation hearing. And so I think those are a couple of different ways that people might consider what's needed in expanding and building out legal capacity, not just for trained attorneys and legal offices, but also community-led initiatives through the participatory defense strategy.
Cool.
Thank you, Nicole. I want to shift and ask a question from the audience. And Shireen, since you're directly dealing with representation, this might be for you. We had a question that was asked about injecting attorneys into the process. Wouldn't that create a level of discrimination and disparity for those that have access to attorneys and those that don't?
So it's a great question. What it's meant to actually do is the absolute opposite, which is right now you have folks who can afford attorneys and they get better treatment, and you have a vast number of people who can't. And so what we intend to do is train a big cadre of attorneys that are willing to provide free representation so that everybody inside the prison system that wants an attorney and can't afford to pay for it, or even if they can and they choose to have one through this system, will have one. So that's the ultimate goal. So there aren't have and have nots. It's not going to happen overnight, but that's the goal.
I was just thinking too, it's like as a formerly incarcerated person who, we advocate for so many things in this country, from just changing policies, laws, addressing the collateral consequences that are attached to a person's felony conviction in this country. But, I was just wondering, like, what could be the role of the formerly incarcerated people? Because when we think about, like, how do we shift parole in this system, I truly believe that we have to have more formerly incarcerated people's voice at these tables when it's coming around probation and parole, not only just training lawyers, but possibly in placing formerly incarcerated people on the boards here across this country that have an opportunity to share their lived experience, the things that they learned in this process of probation and parole, to be able to enlighten and inform the members on the board who may not have that privilege of gaining information. But that's just a thought that I have out loud. I know that's that we can definitely unpack more, but I was just like, because I truly believe that formerly incarcerated people, those who have had this experience, should definitely be, yes, I know, I think one of the sisters went through the Leading with Conviction. What's her name? Kimberly Smith?
Kimber.
Yeah, Kimbra, definitely. I love that, sister. And I would love to see that across the nation where we have formerly incarcerated people having these discussions, building relation with probation and parole, because I truly believe this system is going to change. We have to consult those who have been in the system because we have the solution, but sometimes we are further away from the table of discussion to bring about that change. But that's just a thought. Definitely we need to emulate that more in with what they're doing in Virginia. Hakeem?
Yeah. So, I mean, you're right on point, and we're getting closer to wrapping this up. We have about 15 minutes left. What we want to do is we've asked a question from the audience a little bit. I would love to see some more questions coming from them. But we really want to move forward with kind of getting to some final thoughts about what are some of the next steps that you all see moving forward and how we address the parole system and bring about change and perhaps preventing people from even entering the system to begin with. Dr. Alexandra?
I can say a lot on prevention. I have lots of ideas, but really, for me, it starts with children and then their families. So it's all related. There's no children that are outside their environment. So again, the more people are released and they can have healthy families and stable homes, then the children we're talking about can then have better environments. And hopefully that will also translate into them being in better situations and not be then part of the system. So it's a big cycle, and that kind of speaks also to what Lester was asking about the involvement of people that were incarcerated. It's a crucial step, and perhaps the one that it's not as prominent in our communities as we need, because not only the people can provide insight for the parole board, which I think should be mandatory, that there is a post-incarcerated person in every parole board, but also to strengthen the communities. If we strengthen the communities, then we can hopefully have that manpower to take care of our children, who then will have less likelihood of going through the system, and then trickle farther down the road. So we struggle with school to prisons pipeline in South Carolina, and I cannot emphasize that enough. I really believe in engagement and involvement in political system of everybody, especially our communities, whether it's the participatory defense where communities are involved to reform and rewriting laws and speaking at the legislatures. Believe me, the legislators know only as much as we educate them. So if we do not knock on their doors, and if we're not there at the hearings speaking about the issues that are crucially important, then they will not know, and they will start focusing on their little political agenda. So I think the voice needs to be heard, but the voice needs to be there to be heard. So I really would encourage that grassroots element, especially in South Carolina, that sometimes gets a little bit lost. Perhaps we don't have as strong of a focus, but I think this is an opportunity, and like connecting with people like you, Lester, is like I see that happening, just like with the ACLU. So I don't want to take much more of the time, but that's really speaking up and being heard and getting involved, especially for people that have that experience to share with, because it's crucial for all of us to learn about it and then be empowered with the knowledge.
I didn't want to jump in front of Nicole. If you had,
I did have some comments to make.
Go ahead. I'll go later.
Well, just one thing is to have, and I see the comments in the chat, and one question from our friend Ron, if panelists could rebuild the parole review process, what would they do from the ground up? And so I think in the context of this, one thing is to have an anti-racist lens on the policies and practices that disappear people to prison and then create pathways out of prison, or pathways from under the weight of the community supervision system. And critical race theory has been has been outlawed in many states. I don't know if South Carolina went there this year, but understanding how the laws and policies as they currently are and have been adopted over time disadvantage Black residents to begin with, from the point of arrest to the point of sentencing to the point of parole review process, discretionary parole, understanding that racism is embedded in the code, and then working to find ways to undo it, if not recalibrate the entire process so that disadvantage is not reinforced at the individual level and overall. So what does that mean? Trying to, I think, codify these presumption towards release factors into the code so that people's bias cannot be reinforced. The parole board members' biases, other criminal legal practitioners' members' biases cannot be reinforced behind a risk assessment or some non-transparent practice that can't be countered through the process if the person can represent themselves or has the appropriate representation to them. And frankly, there should be presumptions against imprisonment for a range of things, because we send people to prison in this country that they don't get sent to prison for in other parts of the world. So that should change. So that's about sentencing reform. That's about changing underlying practices that send people to prison, not just a crime of conviction, but also the technical violations that might send somebody to prison too. So I'll stop there because I know we're getting close to the time.
I hate this 1 hour, because it's like so much. My mind's want to respond back to you, Nicole. I don't want to take up so much of it, but I just want to say thank you for what you just shared. And hopefully those who have an opportunity to see the replay or viewing this now really stop and pause and listen to what you just said. Not only you, but all of the panelists. But that right there was very powerful, changing the lens of how we see it. So Shireen?
I'll be brief as well. I agree. Everything you just said, Nicole, very powerfully stated. And also, Lester, you're absolutely right. It should be in our statute that we have at least one person who is formerly incarcerated, always a member of the parole board. And the fact that it isn't is, one of the biggest problems. But there's three other things that haven't been mentioned, I think, that I would hit on that I think we need to have in terms of reforming our system. One, our funding mechanism in South Carolina. We should never have a parole and probation community service system that is funded by the people that are under community service supervision. Where's the incentive there? It is to keep more people in the system. It is not to get them off. And so that needs to be changed. It should not be funded in that manner. Secondly, talking about different approaches and how we can prevent people from becoming under community supervision or incarceration in the beginning, we need to really expand our view of what restorative justice options there are in this state, and look at what we view as the definition of a victim. How many times have people who are in prison or on community supervision been victimized in their life before they ever landed in those situations? Victimized by terrible educational systems, under-resourced neighborhoods, and over-policed neighborhoods. So definition of a victim giving a statement at a parole board should be expanded to include the people that are victimized in other ways as well. And finally, I think we need a lot more oversight over what the parole board is doing. And, they should be able to defend if they are getting a low parole release rate. Why are they deviating from the factors? Why do they continue to reflect their reason being the original facts of the crime, which are unchangeable? That should not be the reason for almost everybody being denied parole. You should be looking at what happened once they were sentenced. What did they do? If they took programs and doing all the right things, then the presumption should always be release. And I'll stop because I know we're also out of time, almost out of time.
Wow, very powerful. Thank you all for those wonderful insights. We want to wrap up with a final question, right? To give you all a chance to give us a kind of conclusive statement, which is very important to this discussion, because as we talk about a call to action, how do we get into action to really do something about this? It begs me to ask this final question, a final thought from you all. So let's take, for example, the state of Wisconsin. 43% of currently incarcerated people in the state of Wisconsin's Department of Corrections are there for parole revocation. That's a crisis, right? That means that half of their population just about are there not for committing crimes, right? They've already committed crimes in the past. They've been sentenced and punished for them, and now they're simply back for a rule violation. That's a crisis. How do we in this country bring awareness to our communities and to our public to let them understand that situations like this is a crisis, and that continuing to hold people in prison for these long periods of time is harming our communities? How do we bring awareness to America about this crisis? Nicole?
I mean, I think there should be national campaigns, which I think you all are doing, but needs to be more amplification of presumptions against prison. And technical violations is one way to start. People should not be in prison for a technical violation. As I've gotten older, I just think the solutions become bolder and clearer. There are things that we send people to prison in the United States that they should not be sent to prison for, and technical violations is one of them.
Thank you. Shireen?
I completely agree with that. I can't believe that we haven't mentioned that up till now, because I'm sure it was on all of our minds that it should never, technical violation should never be a reason to return anyone back to incarceration. This state, as of 2010, did reduce the percentage of people they did that with. So they've shown that it can be done safely, efficiently, and well. And we just need to absolutely bring that number to zero, that no one who has a technical violation should ever be sent back.
Dr. Alexandra?
Well, I personally have learned about this issue many years ago when I was watching documentaries, and there were some powerful ones that really brought it home for me. And I always believe in learning through documentaries and having, panel discussions. So perhaps, as Nicole, you were saying, having a campaign and having a broader really message sent out everywhere, and having then those local communities pick up those conversations and taking them to the table of the legislators. That law has to change. We need to absolutely change the law for those technical violations not to be part of the incarceration process. And it can happen, because really, when somebody chooses for that to happen, that law will change. But it does come with community awareness, I believe, and just like even the lawyers that we're talking about, the involvement of lawyers in the parole process. I believe the more of that will happen, then again, that's when people get really upset, when they really see it. When people live their lives without seeing it, it kind of is easy to keep on going. But it becomes personal to you when you're the one involved on the case, and this case doesn't go anywhere. And I think, so among the communities and legal communities as well, there is really a possibility for people getting upset and speaking up.
Shireen, final thought?
Final thought, I promise. One excellent program, and you triggered this by mentioning documentaries, Alex, that I think we should have a road trip where every community needs to have a showing of the Larry Krasner program. They tackled these issues of probation and parole in Philadelphia, which had an extremely high rate of community supervision. And they aren't the answer to everything, but it is a very good example of some of the ways to do that. And we do need formerly incarcerated people at every aspect of the criminal justice system to explain to the public at large what the damage is of our incarceration policies.
So thank you all. I wish we had a little more time to really unpack so much powerful information that will definitely give our audience and those who get a chance to see this replay some real actionable steps. The reason why we started our campaign, which is called the Just Us campaign, is because after doing COVID-19, we realized that there were so many people inside of the prison system that were impacted with COVID, but very few people were paying attention to the conditions of it. And we unpacked that, and we realized that prisons have always been in a situation where they never considered the people inside of prison as humans. It's always been from the beginning of 1886, when they so-called abolished slavery, to this very day. Prison have always been set up to dehumanize and exploit the labors of people that are currently incarcerated. So we realized with this Just Us campaign is that there were no emergency management strategies set in place to address this pandemic that was ravishing the prison system. And even to this day, it isn't. So our call of action with this Facebook Live, the Just Us Facebook Live, is to ask everyone who has a chance to watch the replay or currently watching, go to justus.org and sign up, sign the petition, share information about the Just Us campaign so that we can get our legislators to pass more bills around the emergency management so that we can put these things into place to protect the people that are currently in prison and in jails and detention centers from natural disasters, pandemics, such as we have this experience with the COVID-19, as well as get involved in your local communities around probation and parole. Know and understand that true transformation of a system does not take place when we're standing on the sidelines, not amplifying our voice. So be inspired by this video, this Facebook Live today, to get involved in your local community around probation and parole. Do whatever you can, and you can connect with us also by going to justleadership.org and find out some more information about what the organization is doing and be connected with all of the leaders that are part of this great organization. And thank you, Hakeem. You have anything you want to say in closing?
Nope, not at all. Thank you all for joining us. Thank you, Dr. Alexander. Thank you, Nicole. Thank you, Shireen, for joining us with Live with Just Us. We are powered by Just Leadership USA, an organization, national organization that believes that those close to the problem are those close to the solution, but they are furthest from the access to the resources and the power to bring about a change. And this conversation brings us closer to those resources and power to bring about a change as we begin to network and drill down conversations that are important to us in this country. So thank you all for joining Just Us today. We're sending a sign off to everyone that joined us live. Thank you all for joining us, and we'll see you next time.
Thank you.
Thank you.
Thank you so much.